Good morning and welcome to today's edition of Coffee and Contracts. Today we're going to continue our conversation about the offer to purchase, the North Carolina Standard Offer to Purchase Form 2T. We have successfully talked about our page 1 and page 2 terms. We finished up on page 2, and at the end of page 2 was the due diligence period and settlement date. Now on page 3 we're going to actually take the time to distinguish for brokers and buyers the difference between closing and settlement. Remember that they are not the same. Typically they are synonymous, but settlement is when we actually sign all the paperwork. Closing is when the closing actually takes place. So in most cases they happen around the same time, but it could be in fact a period or an option for an attorney to close it on, let's say, 3 or 4 o'clock on a Friday. And so while we call it a closing on Friday, it's actually settlement. Settlement's when everybody comes, all the paperwork signed, loan docs, closing disclosures, everything's signed, but we don't have a closing until it's officially recorded. The new deed has to be taken to the courthouse or sent via electronically to the courthouse for which the county which the property's in. And once it's on record, then we have successfully closed the property. And at that point, buyers can have keys, sellers can have proceeds, agents can get commission checks. We are considered closed. So, and page 3 of the contract, which talks about that continuation from the bottom of page 2, it does distinguish the difference between settlement and closing. You need to make sure folks are prepared that we can't give you keys or possession of the property until we are on record. So if that does happen at Friday afternoon and we can't record, you may not get keys until Monday morning. So you need to have a contingency and have a plan built in for your folks, both buyers and sellers, to make arrangements in those situations. Also wanted to highlight the box on page 3 that says that North Carolina is a settlement state that requires an attorney to conduct our closings. Now it may be that you have a closing and the attorney is not necessarily present. They could send a representative, a paralegal, notary, but ultimately the attorney is responsible for that. Things like the title search and the title assurance, those things are done by an attorney and they are responsible for that. So just know that your buyer typically gets to choose their attorney. Seller can also choose an attorney for representation to create their seller docs, their new deeds and lien waivers. It's not uncommon for both buyer and seller to use the same closing attorney just for the sake of simplicity, but if you're on the listing side, it's prudent. Call the buyer's attorney and say, hey, what do you charge for seller docs? What does that look like? And is that in line with what you expect? And if so, you may have a conversation with your seller about whether they want to use them. Also, do ask your sellers, because some folks actually get things like free legal aid through their work. They may be able to get their own seller docs done, and you don't want to have to pay another attorney to do that. So have a good conversation with them about that process and how we are an attorney state, and we close at attorneys, especially with folks coming out of state. They may say, hey, we're going to go to escrow, or we're going to go see the title company. Title companies can conduct closings in other places, so that's not typical. Our practice here, we are really an attorney state where we close at attorneys. So out of state folks, you may have to educate them. Under Section N defines special assessments, and special assessments are basically any kind of charge that it may be showing up against a property. We think of these in the form of maybe a municipality assessment for a sidewalk, for street lamps, sewer assessments. The other thing that it could be is maybe an HOA assessment. Hey, we're going to repave the parking lot, we're going to put new decks on the townhouses or the condos. So those things are assessments from an HOA. And so the way the contract reads is that a special assessment that has been confirmed, meaning we know that it's going to happen and we know how much it's going to be, those special assessments are paid by the seller if they are confirmed. If we are talking about assessments and they've been proposed but they've not been finalized and we don't know what that looks like, the buyer then is purchasing the property assuming any proposed assessments. And so that's the way the contract is going to read out. And so that's under Section N on page 3. And then we get into paragraph 2. And just like that, we're 3 videos in and we're on paragraph 2 of the contract of 23. So I wanted to talk to you about fixtures and exclusions. This is probably one of the most common areas that brokers, buyers and sellers are still getting confused and getting themselves into adverse situations. A fixture is anything that is screwed, glued, attached, bolted, or in any way affixed to a property that a buyer would expect to be there when they close. So for example, it always seems to be the chandelier. Chandelier does not convey. It's the seller's personal chandelier. It's been in the family forever. First of all, take it down before we put it on the market so no one sees it. No one says, hey, I want to buy the house because of that. That's the best practice. But if it is there, we need to make sure we exclude it. And we'll talk about that on the next page. But there's some things people don't consider fixtures. So at the bottom of page 3, I'm not going to read it to you, but there's a long list of fixtures, potential fixtures, not inclusive, all-encompassing list, but pretty exhaustive, that includes things that you might not think about. Pool equipment, remote controls for fans and garage doors. The curtain rods are a fixture, but the curtains themselves are personal property. Blinds are a fixture. So it goes to a whole list of things that you need to be aware of when you're having a conversation about listing a house, but also when you're having a conversation with your buyer. Again, dealing with folks that may be moving from all over the state, all over the country, all over the world, they may have different expectations. So we want to take the time to explain to them what are our fixtures and what are not. For example, I had a gentleman moving from Virginia here, and in his part of the world, it was customary that the refrigerator, washer, and dryer were always included in the purchase, and that was not the case here. So I had to explain how that works, and that was, if that's something you want, we can certainly ask for it, but it's not automatically a given. That's the fixture section, and I think that wraps up our page 3. So we'll see you on page 4 of the offer to purchase.